the oversight hearing on the employment section of the Civil Rights Division of the U.S. Department of Justice. Invite all witnesses to retake their seats as the hearing commences. Remind all witnesses that their written statements will be made part of the record in its entirety, and the chair is informed that the next witness is Janet Caldero. Ms. Caldero, you may proceed.
Good afternoon. I'd like to thank Chairman Conyers, Chairman Nadler, and Ranking Member Franks and Congressman Davis for giving me the opportunity to testify today. My name is Janet Caldero, and I work as a custodian in public schools in Queens. In New York City, custodians are building managers for public schools. We hire our own staff and manage our own budgets. These are good-paying supervisory jobs with civil service protections, and I am proud to do the work I do. I am especially proud to be one of the very few women in the New York City system. I am here today on behalf of all of them, and one other fellow female custodian has taken the time to be here today with me. Before I became a custodian, I had worked in public schools for many years as a secretary and then a handyman. At that time, I knew of exactly one woman custodian. In a workforce of close to 900, there were fewer than 10 women holding these jobs. It was hard to break in and learn how to get the job if you were an outsider. In 1992, I was hired as a provisional custodian. Being provisional means that you have no job security. Many of the women and minorities who worked as custodians back then were hired provisionally. When I was hired, I was a single mom with 2 teenagers at home. I needed this job, and I worked hard to get it. It was about the time I was hired that the Justice Department began to investigate the New York City Board of Education's hiring practices for custodians. In 1996, after several years of investigation, the Justice Department sued the Board of Education. The lawsuit alleged the board's hiring practices discriminated against women and minorities. While the case was in court, I talked to the attorneys for the Justice Department many times, as did several of the other women and minorities who were working provisionally. I understood the Justice Department attorneys to be working on my behalf and on behalf of other women like me who were working hard to succeed in a place where a lot of our male colleagues thought we didn't belong. I thought of them as my attorneys. In about 2000, I learned that the Justice Department and the Board of Ed had settled the lawsuit, and the Board of Ed had agreed to extend permanent employment and retroactive seniority to women and minorities who had been hired provisionally. As a result, those of us on the job were more visible, and I think this sent a message to other women and minorities that they could do this work as well. After these benefits were awarded, a group of white male custodians objected and argued that the settlement discriminated against them as white men. Then in 2002, long after the Justice Department had signed the settlement, I got a call from an American Civil Liberties Union lawyer. She told me that the Justice Department had changed its position and was no longer defending parts of the settlement in the face of the white male custodian attacks, including the awards to me and most of the other female beneficiaries. I didn't believe her. I heard nothing from the Justice Department. I immediately called the attorney at the Justice Department whom I had been working with before, but instead I was transferred to someone I had never heard of. I asked him whether it was true that the Justice Department was no longer defending my interests. He said the Justice Department was continuing to defend the settlement. The attorney from the ACLU sent me a brief the Justice Department had filed in court that listed the names of the beneficiaries it was still defending. Fewer than half of us were on that list. I wasn't on it. When I called the new Justice Department lawyer, he refused to answer any of my questions. The ACLU then entered the case representing me and more than 20 other beneficiaries whom the Justice Department had abandoned. Since 2002, the Justice Department has argued that the awards it won for us discriminated against white men, who still make up the vast majority of New York school custodians. We have had to live with the possibility that we might lose our seniority and have our salaries reduced. If this happened to me, for instance, I would have to sell my home. Those who receive permanent employment have to worry about losing their jobs. Last year, the trial court ruled against the justice in a large part, but the fight isn't over. The Justice Department and the white male custodians will almost certainly appeal, and so our uncertainty on the job continues. I don't fully understand the legal issues in this case, but I do know that it's hard to be a woman custodian because too many people feel women can't do the job. The Justice Department came to me saying that the United States government wanted to change this. I trusted the Justice Department, and then it betrayed and abandoned me and many others. This was unjust and unfair, and I hope that no one else ever has to go through this experience. The Justice Department needs to honor its commitments. I also believe that it should spend its energy fighting on behalf of people like me, women and minorities trying to succeed in jobs they have long been denied. Thank you.
Ms. Caldero, thank you. We proceed to Eric Dreiband. You have 5 minutes, Mr. Dreiband.
Thank you, Representative Davis, Ranking Member Franks, and members of the subcommittee. I thank you and the entire subcommittee for affording me the privilege of testifying today. My name is Eric Dreiband, and I'm a partner at the law firm of Akin, Gump, Strauss, Hauer, and Feld. Prior to joining Akin Gump in September of 2005, I served as the General Counsel of the United States Equal Employment Opportunity Commission. As General Counsel of the EEOC, I directed the federal government's litigation of the federal employment discrimination laws. I also managed approximately 300 attorneys and a national litigation docket of about 500 cases a year. Now, EEOC enforcement authority over Title VII is plenary, with the exception of litigation against public employers. Title VII vests the EEOC with independent litigation authority against private employers. The Employment Protections of the Americans with Disabilities Act incorporate Title VII's enforcement scheme, and so the EEOC also litigates disability discrimination claims. EEOC enforces two other statutes, the Equal Pay Act, which prohibits sex-based wage discrimination, and the Age Discrimination in Employment Act. Collectively, then, the Congress has vested the EEOC with authority for enforcing a broad array of employment discrimination laws, including laws that protect American workers against discrimination on the basis of race, color, religion, sex, national origin, age, and disability. I was honored to contribute to the enforcement of the federal civil rights laws when I served at the EEOC. Every member of the administration with whom I worked unambiguously and enthusiastically supported the EEOC's efforts to continue and improve upon its enforcement programs. This included officials at the Department of Justice, including especially the Civil Rights Division and the Office of the Solicitor General. During my tenure at the EEOC, the Commission continued its tradition of aggressive litigation. We obtained relief for thousands of victims of discrimination, and the EEOC's litigation program recovered more money for victims of discrimination than at any other time in the Commission's history. The Commission filed hundreds of cases every year and recovered literally hundreds of millions of dollars for victims of discrimination. Here are some examples. In EEOC versus Morgan Stanley, I personally intervened and negotiated, with the help of others at the EEOC, a historic $54 million settlement of a sex discrimination case brought by the EEOC on behalf of a class of women who worked for a major Wall Street investment firm. We also obtained one of the largest EEOC settlements ever in the agribusiness industry. In EEOC versus Rivera Vineyards, the Commission sued and recovered substantial relief for a group of employees, mostly Hispanic women, who were allegedly sexually harassed, retaliated against for complaining, and segregated into certain jobs based on gender. Likewise, in EEOC versus Abercrombie and Fitch, the EEOC resolved a nationwide race and sex discrimination case against one of the nation's largest retailers. In that case, the EEOC alleged that the defendant maintained recruiting and hiring practices that excluded minorities and women and adopted a restrictive marketing image and other policies that limited minority and female employment. In EEOC versus Seafarers International Union, I appeared on behalf of the Commission before the United States Court of Appeals for the Fourth Circuit and successfully defended the EEOC's position that the federal age discrimination protections extend to apprenticeship programs. As a result of that case, workers who are over age 40 and may need training are protected against age discrimination. And in Supreme Court litigation, the EEOC worked with the Civil Rights Division and the Solicitor General of the United States. In General Dynamics versus Klein, for example, we filed a brief on behalf of a class of alleged age discrimination victims. Likewise, in Pennsylvania State Police versus Suitors, we successfully defended the rights of Nancy Drew Suitors after she claimed that she was the victim of shocking and despicable sex discrimination by her employer. The Commission also worked successfully with the Civil Rights Division and the Solicitor General in Maldonado versus City of Altus, Oklahoma. In the United States Court of Appeals for the 10th Circuit, we defended the rights of several individuals who asserted claims of race and national origin discrimination, and the 10th Circuit agreed with us. Finally, it is important to remember that the folly and disgrace of unlawful discrimination continues to plague our nation. Enforcement of the civil rights laws vests the EEOC and the Civil Rights Division with sacred responsibilities that speak to the very essence of who we are as a people and who we aspire to be. It was my professional and personal privilege to serve with all of those women and men of the EEOC and the Civil Rights Division. These are individuals who have dedicated their lives to our continuing struggle to live up to the legacy of Anthony Burns, William Lloyd Garrison, Frederick Douglass, Abraham Lincoln, Charles Sumner, Susan B. Anthony, Martin Luther King Jr., Everett Dirksen, Roy Wilkins, Evan Kemp Jr., and countless others.
Mr. Dreiband, let me ask you to close. We have a very tight time constraint today as we literally have to vacate the room, so if you could quickly wrap up.
I'm finished. Thank you, and I look forward to your questions.
Thank you, Mr. Dreiband. The next witness is Jocelyn Frye. Before you go, Ms. Frye, may the chair inquire if there's any representative of the Department of Justice who's present in the hearing room today? Signal by a show of a hand. May the record reflect that there is no representative of the Department of Justice who remains in the hearing room. Ms. Frye, you have 5 minutes.
Thank you, Congressman Davis, and in his absence, to the chair and the ranking member and the other members of the committee. My name is Jocelyn Frye. I am a general counsel at the National Partnership for Women and Families. I appreciate the opportunity to testify today. I know that given the time constraints that we have, I want to focus on a series of concerns that we've raised and the testimony that I submitted and also some recommendations. I first want to start by saying that we are strongly committed to the mission of not only the Department of Justice, but particularly the work of the employment section. From the perspective of many advocates, we care deeply about the broad mission of ensuring equal employment opportunity and eliminating discrimination in the workplace. Our view is that the employment section should do a number of things, but at a minimum, it should be fully committed to vigorous enforcement of employment discrimination laws. It should be a strong leader in investigating allegations of job discrimination and advance legal arguments in the courts that extend maximum protections to victims of discrimination, particularly under Title VII of the 1964 Act. Unfortunately, over the last 6.5 years, there are a number of concerns that we've had about the direction of the employment section, and I'll lay them out for you. The first is a decline in the employment section's overall enforcement numbers and their litigation numbers. As others have mentioned, they're on track to file roughly about half of the Title VII cases that were filed in the prior administration. Second, there's a concern about perceptions of decreased emphasis on cases that have traditionally been pursued and have been a high priority. One example is race discrimination cases involving African Americans. I would also add a concern about gender discrimination cases as well. Thirdly, there's been a concern about a fewer number of pattern and practice cases, disparate impact cases, and cases that, as a general matter, are used to uncover systemic practices in the workplace that can have larger effects on a larger number of employees. There are a fewer number of those cases under this administration than the prior administration. Reversals of long-time legal positions in cases that the end result is less protection for discrimination victims, and it makes it much harder for people to vindicate their rights. Allegations of improper political influence in terms of attorney hiring and also the decisions ultimately that are made in the direction of different cases. Lastly is just a concern about the lack of leadership and visibility to draw attention to the persistence of employment discrimination, the legal protections that are available, and the obligation of public employers to comply with the law. There are many components of each one of those concerns, but that's a broad summary of the concerns that we've raised. In terms of recommendations, I want to offer several for the subcommittee to consider. The first is that we believe that the section ought to have consistent support for legal interpretations that provide maximum protections to discrimination victims. It's essential that the employment section and the Civil Rights Division more broadly advance legal arguments that preserve and do not roll back the ability of victims of employment discrimination to vindicate their rights. Increased transparency and accountability. As many of you, I'm sure, sure are even more aware than we are, it's very hard sometimes just to figure out how many cases the section is bringing on a regular basis. And we believe that it's crucial to have regular reporting. How many complaints are they filing? How many resolutions are there? That type of thing that would go a long way to ensuring that we have regular accountability of the work of the section. Thirdly, establishing high goals and priorities. There ought to be something that we can measure the success of the section by, rather than sort of rhetoric. We'd love for them to have some clear goals and priorities in terms of their direction. Eliminating improper political influence in the hiring process and also case decision-making. Allegations of political preferences and affiliations that trump solid experience in civil rights enforcement when making attorney hiring decisions has harmed the stature, morale, and ultimately the effectiveness of the section. Regular oversight hearings like this are crucial. And lastly, leadership and visibility. It's essential that the leaders of the employment section are viewed as leaders on employment discrimination. The employment section has a critical role to play in preserving, defending, and upholding rights and protections of critical importance to ensure fair treatment in the workplace. We believe the section's record over the past 6.5 years has fallen short of what is needed to make the promise of equal employment opportunity a reality for all workers. Thank you for the opportunity this morning.
Thank you, Ms. Frye. Let me thank all the witnesses for your conciseness given our time constraints. I will begin the questions by recognizing myself for 5 minutes. And Ms. Frye, if I can begin with you. The first witness and the first panel today, Mr. Agarwal from the Justice Department, made a number of assertions to the effect that this administration's civil rights enforcement record, at least with respect to employment cases, was comparable, if not identical, to that of the Clinton administration. Would you care to comment on that representation?
Well, it's certainly not our understanding of their record, just based on a review of the complaints that we have access to on their website. And I first want to concur with the comment that I believe the chair of the committee made, Mr. Conyers, which is this also has to be understood in a broader context. The Clinton administration wasn't necessarily the high watermark when it comes to employment discrimination cases generally, but it's certainly a measure that we want to use. But when you look at the numbers overall in this administration, they're fallen well short of the Clinton administration. When you look at Title VII complaints overall, again, they're roughly about half of where the Clinton administration was, on track to do maybe 45, maybe close to 50, but that's roughly half of where the Clinton administration was. If you look at pattern and practice cases, again, they're on track to do about half. They've done 13 thus far. What's of most concern is that when you look at some of the areas where they've traditionally focused, discrimination against African Americans, they have 4. The first case that was initiated by the employment section actually wasn't brought until last year. They have 2 that are pattern of practice cases involving women. They have the same number involving discrimination against women as they have against men. Those numbers, again, are quite low. We're looking at the big picture, and over 6.5 years, the record just doesn't reflect the level that we would think that they'd ought to be at.
Ms. Frye, let me pick up on that. As someone who's knowledgeable in the area of civil rights and employment law, do you have any empirical reason to believe that there has somehow been dramatically less discrimination in the last 6 years than there was under the Clinton administration?
No, I certainly don't have any evidence like that. And if you look at the Equal Employment Opportunity Commission, where they receive charges of discrimination, they receive thousands of charges a year. And while not all of those are meritorious, certainly a good percentage are. The
private filings with the EEOC, I take it, are roughly consistent during the last 6-year period with the decade before that, which would suggest there's not been a drop-off as a systemic matter in discrimination claims in this country. You'd agree?
I'd agree.
Let me turn to you, Mr. Dreiband. You talked very eloquently about the historic mission of the Department of Justice. Give me some perspective on that. What conclusion do you take when you hear Ms. Frye talk about a pattern of less enforcement than before, when you hear Ms. Frye talk about a pattern of changing position, changing the side that the Justice Department tends to back in these cases? What does that say to you about this administration's commitment to the historic mission of the Department of Justice? If you could be very brief.
Yeah, well, you know, what Ms. Frye described is not what I experienced as a member of the administration. I mean, I was appointed by the President to serve as the EEOC General Counsel, and I found an unwavering commitment to fair and effective and aggressive enforcement of the civil rights laws.
Do the numbers mean anything to you? What do the numbers suggest?
I mean, I'm familiar with the numbers at the EEOC, and all of those numbers were much higher during my tenure as General Counsel than they were during the previous administration, including a number of Title VII lawsuits filed, a lot more money recovered under our tenure than under our predecessors. We set records for recovery through the EEOC's litigation program, recovered literally hundreds of millions of dollars. And in the Civil Rights Division, my dealings with people there were always professional, cordial, and reflected a commitment to effective law enforcement. So with regard to the particular numbers, I'm not as familiar as Ms. Frye is with the number of cases, for example, the Civil Rights Division has filed. I do know that in my dealings with them, they always express to me, you know,
Are the numbers relevant to you, Mr. Dreiband? Ms. Frye put a lot of stock in the numbers. The fact that she ticked off 3 or 4 categories where there's a significant numerical decline in the cases brought by this Justice Department and those brought by the previous ones. And what I'm trying to press you on is, what do those numbers mean to you? How do you explain that drop in numbers? Would it be your position that there's been a drop in the amount of acts of discrimination somehow that have occurred in the last 6 years? Any empirical basis to believe that?
Well, I didn't see any kind of drop-off in terms of the charge filing data that we had at the EEOC, nor did I see at EEOC any kind of reduction in number of lawsuits. In fact, the opposite. We brought more cases at the EEOC. Now, at the Justice Department, I didn't review their files.
Let me cut you off simply as of time, Ms. Franks. Ms. Caldero, I'll ask you just one quick question before I turn to the ranking member. As a private litigant, what did it say to you, if you can be extremely brief, what did it say to you as a litigant when the Justice Department changed sides in your case?
I felt that they were
Turn on your mic, please, ma'am.
I felt that they acted very unprofessional, and I felt betrayed by them, that they didn't stand, you know, up for the settlement agreement like they had told us that they would.
Did it cause you to question the department's commitment to equal justice?
Absolutely. The other female custodians and myself, we look at them now as the Injustice Department, not the Justice Department.
I turn now to the ranking member for 5 minutes.
Well, thank you, Mr. Chairman. Mr. Chairman, I think if it's all right, I'm going to address Mr. Dreiband and ask him kind of along some of the same line questions that you were asking. You know, we've heard some conflicting testimony here today, and I quite honestly and sincerely don't know which is correct, so let me give this to you in a two-part question. Some of the testimony here has indicated that there's been a drop in racial discrimination cases and an increase in cases intervened on based on religious discrimination. And my first question is, do you think that's true? And number two, along the lines the chairman mentioned, do you think that there is any difference or any trend in society where there's any downtrend toward the racial discrimination and uptick in religious discrimination?
Well, with regard to religious discrimination, certainly the EEOC has seen an increase in the number of religious discrimination charges filed with the EEOC, and so as a result, one could envision more religious discrimination lawsuits being filed both by private litigants and by the EEOC and the Justice Department. That could explain what apparently is the different numbers that people have talked about. You know, I'm not personally familiar with the Justice Department's statistical record with regard to religious versus race discrimination claims, but I do know, as I say, that there has certainly been an increase in the number of religious discrimination charges. I know at EEOC, for example, we filed, when I was General Counsel, hundreds of Title VII cases a year under alleging race discrimination as well as religious discrimination, and we brought lawsuits without fear or favor or to any defendant or without regard to the type of discrimination we encountered. Our goal and the efforts we undertook was to eradicate unlawful discrimination where we found it, of whatever kind.
So is it your testimony, Mr. Dreiband, that the trends, whatever they may be, are more reflective of the cases filed with the EEOC And secondarily, in overall numbers, it's also your testimony that in terms of the previous administration, that your enforcement numbers have been up rather than down. Is that correct?
Well, that's certainly true with regard to the EEOC's litigation program, yes. The EEOC has filed more Title VII cases under this administration, recovered more money for victims of discrimination under this administration than the EEOC did under the previous administration. With regard to charges, it's important, I think, to note that the EEOC receives charges from individuals all over the United States, and as those numbers change, we do see a trend at times with the outcome being more types of lawsuits reflecting the types of charges that the Commission receives.
Well, thank you, sir. Professor Ugelow, in your testimony, I was curious, do you assert that the section is disregarding the laws it's mandated to enforce, or really simply pursuing what might be reasonable interpretations that you disagree with?
Oh, I think they're ignoring litigation against African Americans.
You think they're disregarding the laws, is that correct?
I don't think they're enforcing the laws fairly and vigorously.
Okay, let me go ahead and follow up then. The division in this section have been criticized, as you know, in some quarters, certainly even here today, for initiating actions where the alleged victims were either white or Christian or men. And do you agree that the division deserves the criticism? And if so, help me understand why you think they deserve the criticism in that regard.
Well, implicit in your question is if we do one type of case, we can't do another type of case. And I don't think that's correct. You can do religious discrimination cases without ignoring cases involving Latinos and African Americans. And my contention to you, Congressman, is that the section has deliberately reduced its enforcement of the civil rights laws as they affect African Americans and Latinos. It's not either or. Religious discrimination cases are important. We can all agree on that. But there ought to be vigorous enforcement all across the board. And if you look at the numbers, where this section has filed 47 cases in almost 7 years in office, that's well below what the three prior administrations have filed. So something's going on. They're not doing something. It's the same staff, same number of attorneys, same number of support staff, but they're not doing their job.
Well, Ms. Frye, let me turn that question to you. Do you think that the division has been fairly criticized for bringing these cases where the victims are either white or Christian or men? Do you think that there's a fair criticism there for them bringing and initiating those actions, and if so, why?
Well, and Ms. Frye, the gentleman's time has expired with that question. You can answer the question given our time constraints.
Okay.
Thank you, Mr. Chairman.
I want to be clear. I don't think that anybody criticizes the department. I certainly don't mean to, for bringing legitimate cases of discrimination, regardless of who it involves, whether it's a white male or a person because of their religious beliefs. That's not really the concern. It's a broader concern about what the docket looks like overall. And the reality is that since the inception of the division, and I think it's also the case that since the beginning of the EEOC, the largest number of complaints that they see are race discrimination cases followed by sex discrimination. And when you look at their record now, the reality is that there has been a significant drop-off in the number of cases involving African Americans and Latinos and women, and that's a concern.
Ms. Frye, thank you. On behalf of the subcommittee, the chair notes that no other members on either side are present, and we thank, on behalf of the subcommittee, the ranking member and I thank all of our witnesses for appearing here today and for your testimony. Apologize to you that we had unexpected time constraints in the form of votes and expected time constraints in the nature of the fact that we have to vacate the room to prepare for another hearing, but we thank you for your patience. Without objection, all members have 5 legislative days to submit to the chair additional written questions for the witnesses, which we will forward and ask the witnesses respond as promptly as you can so that your answers are made part of the record. Without objection, all members will have 5 legislative days to revise and extend their remarks and to submit any additional materials for inclusion in the record. And with that, the hearing into oversight of the employment section of the Civil Rights Division of the U.S. Department of Justice is adjourned.